Good afternoon, everybody, and thank you for joining us for today's webinar on workers' rights and protections. This is a joint presentation by the New York State Workers' Compensation Board and the New York State Department of Labor. I'm Mike Gifford from the Branding and Stakeholder Engagement Unit here at the Workers' Compensation Board. For today, we'll be using the chat feature to receive any questions you have during the presentation. Please enter these questions in the chat box that's located on the right side of your screen. You will see it as a chat bubble icon. We'll answer as many of your questions as we can, but if you have questions that we don't get to today, or you think of something after the session ends, we will be providing you with resources at the end of the presentation. We are also recording today's webinar, and it will be available for you on the board's website and the YouTube channel. So now, I will pass it over to the board's chair, Clarissa Rodriguez.
Good afternoon, everyone, and thank you so much for joining us today for the special webinar in partnership with the Department of Labor in honor of Labor Day. Welcome again. I'm Clarissa Rodriguez, Chair of the New York State Workers' Compensation Board, and we're hosting this program today, this joint program today, because the labor movement and the fight for workers' rights is an integral part of New York State's history and the history of both of our agencies, whose very establishment was tied to the labor movement. The first Labor Day celebration was held in New York City in September of 1882, when the city's unions came together to hold a large parade. More than 20,000 people attended the first gathering to show support for the local labor movement as they fought for fair wages, an 8-hour workday, the end of child labor, and safer working conditions. Workers gave up a day's pay to march and show others the benefits of joining a union. Decades later, workers' rights advocate Frances Perkins fought for labor and social reforms after witnessing the devastating Triangle Shirtwaist Factory fire in New York City. Her tenacious spirit and forceful belief in worker safety led to her becoming not only the first woman to serve as commissioner of the New York State Workers' Compensation Board, but also as the first woman to be named to a presidential cabinet position as the 4th United States Secretary of Labor. She was a champion of workplace inspection laws, minimum wage requirements, reduced work weeks, and unemployment insurance. We at the Workers' Compensation Board and at the Department of Labor strive to carry on Mrs. Perkins' legacy today. Our mission at the board is to protect the rights of employees and employers by ensuring the proper delivery of benefits and promoting compliance with the law. Now, while we are proud of the work that we do, we would actually prefer to see fewer claims, because that would mean fewer workers were getting hurt on the job or suffering from a work-related illness. After all, the best accident is one that never happens. Our hope today is that this webinar will help educate all of you on the critical rights and protections you have as workers in this great state, while providing essential information on minimum wage and overtime rules, anti-discrimination laws, and benefits such as workers' compensation, disability benefits, and paid family leave. With that, I'm excited to introduce our first speaker, the board's advocate for injured workers, Joe Cavalcante, who will talk about the important benefits we administer here at the board. He'll be followed by Denise Rodriguez, investigative officer with the Department of Labor, who will share essential information on rights and protections that the Department of Labor oversees. Welcome again to our speakers. Take it away, Joe.
Thank you very much, Chair Rodriguez, and welcome, my friends. We like to begin this now at the point before there's ever an accident or an illness or an incident that would require workers' comp at all. That's a long way of saying, let's do what we can to create safer workplaces. There is a tried and true method known as the Labor Management Safety Committee. This is something any workplace can adopt. It's simple and it's free, and it just involves people talking to each other. On screen, you can see a suggestion on the left about how you might wish to do this, formulate such a committee. And the idea is for the workers and the managers to get together and talk about the places in the work area that could create an incident or that are creating incidents, and do what you can to mitigate that from happening. So you might want to review your equipment, say. Are you using your equipment according to manufacturer's specs? Do you even have the manufacturer's specs at this point? I hope no one's modifying equipment unsafely. And then how about your procedures? Do you have documented procedures? Well, speaking as a former tech writer, you should. And then have you actually reviewed these procedures to make sure that they are the safest way to perform your daily activities? So this is a very simple, free way to hopefully eliminate accidents and illnesses before they ever happen. Now, let's say that maybe something does happen. Well, there's a workers' compensation system. In New York, this is a no-fault insurance system. That means that there is an insurance policy or an insurance plan of some sort in place to pay for the claims when there's an incident. The Workers' Comp Board does not pay these claims unless, we'll talk about that in a moment. The employers must provide this insurance coverage to protect their workers. It's a matter of law. They have to provide it. And the workers do not contribute directly to the cost of the workers' comp insurance. There are other insurances we'll talk about in a moment where they might. Also, if you're injured or made sick at work, workers' comp is your right. You cannot negotiate it away. You cannot sign it away. It's your right, you have it, and as a matter of fact, you can think of the benefits I'm going to explain as a minimum or a floor, because employees can negotiate richer benefits, and that can happen in something like a collective bargaining agreement. Also, immigration status of the worker is not a factor in workers' comp. As a matter of fact, it's not a factor in any of the three insurances I'm going to speak about. The second one's disability, the third one is paid family leave. It's just not a factor in any way. No one is asking, where were you born? When did you come to the U.S.? How did you get here? It's just not a part of these systems. Finally, for background info, language assistance services are available for free from the Workers' Comp Board. So we're tending to conduct most things in English, but if the worker does not wish to read or hear English, we will translate or interpret into another language for that worker at no charge. And as a matter of fact, our printed materials are available, and other materials are available readily in the 12 languages that more than 90% of insurers speak. So now, who's this Workers' Comp Board? Well, that's my employer, Clarissa's employer. We are the New York State government agency that regulates the workers' comp system. There are approximately 1,000 of us at almost 24 offices across the state. How do we do this? We receive the reports of injury, the reports of payment, the medical reports. We get all the documents, in other words. And as part of our duties, one of our most significant duties is sometimes in this system you need to have a hearing in front of a law judge at the Workers' Comp Board. Well, we hold that hearing, and we will speak more about that topic in a moment. The other thing that we do that I mentioned is if an employer is not carrying insurance when they should, well, the board will actually front the money. We'll pay the claim, but we're advancing the payment because what we do is we bill the employer personally to pay us back. So on that subject, who's paying your comp claim? Well, there's going to be an insurer to pay the claim. Now, in New York, that breaks down two ways. The first way is the employer could simply buy a workers' comp insurance policy. They could also buy a disability policy and a paid family leave policy. We'll talk more about that in a little while. And there are hundreds of insurance carriers who sell these policies in New York. So about 2/3 of New York employers tend to do that. The other third self-insure. Self-insurance means that the employer is of such a size and financial position that it can pay the claims out of its own funds. Now, who does this? Well, governments in New York can do this, and by and large, they frequently tend to self-insure. Now, government, city, county, school district, that's a government. The state of New York does not self-insure. The state of New York has a policy. But other government entities in New York, yes, they tend to self-insure, and they tend to hire an administrator to handle the claim for them. Very large corporations, very, very large, like multi-billion-dollar corporations, sometimes they tend to self-insure. There are less than 100 of those who do that, but they have chosen. They also tend to hire an administrator to handle the claims. That means if you're a worker, you are not going to be dealing with your employer if you have a claim. You are not dealing with your HR department or your personnel or your supervisor. You're either going to be dealing with an insurance carrier or an administrator who's handling the claim. Who needs to carry this insurance? This is what we call a foundational concept. If you're an employer and you have employees, you're probably going to need to carry this insurance. When it comes to comp, workers' comp, if you have one part-time employee and you're a for-profit business, you're going to need to have insurance. There's no minimums. And all the workers are covered from day one, moment one. That's a question we sometimes get. So I'm saying that if you have employees, you have to have this insurance. So who might be considered an employee? Well, in the for-profit world, the business is for-profit, anyone who's providing services to that employer could be considered an employee. In the nonprofit world, 501c3, nonprofits, anyone who's compensated could potentially be considered an employee of the nonprofit. There is an exemption in nonprofits for clergy and for teachers at 501c3s. Those can be exempted, but the nonprofit can also choose to provide coverage for them. And also, there's a lot of talk of independent contractors today. Just so you know, when it comes to comp, the board will decide who's an independent contractor and who's not according to the workers' comp laws. It is definitely possible for one to be an independent contractor for tax purposes, but not for workers' comp purposes. So internet businesses, they could have employees, and a number of very large internet businesses do carry workers' comp insurance. When employers choose not to carry insurance, and they should, they are going to be receiving some fairly significant financial penalties from this agency. And if they incur a claim, one of their people gets hurt and they're not carrying the insurance, the board will advance the payments and then bill the owner of the business directly. So now, what do we do if there is an incident? Okay, this is a new topic, but it's very important. You're a worker, you have an incident, you got hurt. What do? Step number one, Go get the necessary medical treatment now. Take care of your health. Our mothers were right. It's the most important thing. Go get your medical care. You can choose where you wish to go. You just got hurt, it's an emergency, your employer is recommending you go to this urgent care, that's nice, but if you'd rather go somewhere else, go on ahead. No one can tell you where to go when you're getting your initial treatment. Just get good care right now. Second thing you do, tell your employer in writing you had an incident. You need to do that because it's going to begin the chain of events that gets you a claim. You tell your employer has to tell its insurance company, its insurance payer has to tell us, or penalties can result. That's called notice. That starts your claim. You went and got treatment, you told the doctor in the office it happened at work. Now they're going to file their medical report and their bill with the insurance company and with the board. Now you have a complete claim. Also, tell your employer in writing, I recommend you use a document or you use an email. You are allowed to text, but I don't recommend you text because you might have to find that text in 11 months and your phone settings might delete your text after 30 days because that's the default setting on Apple and Google phones, by the way. Okay, so you told your employer, we recommend you file a C3 form. You file a claim form with us. It's called the C3. You can get it on the website. You could send it in electronically or you could send it in on paper. It's your choice. It's kind of like a backstop or it's kind of you're telling your version of events. That's fine. We just want to make sure we get the notice and yes, you can file as well. You should keep getting your necessary treatment. You have 2 years to file your claim. You have 2 years to file a claim. However, you can see from what I'm telling you, if you follow these directions, your claim will be filed within days, okay? Finally, just want to point out, COVID-19. COVID-19 is an infectious disease. Infectious diseases are payable in the New York workers' comp system. Don't worry about how are we ever going to prove that you got COVID at work. We actually use a standard known as what's the likelihood you got it at work. You don't have to point to a moment in time when you might have been infected. So if you got COVID, you think you got it at work, file a claim. Let's talk now about the benefits. There are 3. There's the medical care, there's the lost wages, and then there's the fatality benefit. First, the medical care. Care for the workers' comp injury or illness is provided to you for the rest of your life. It is a lifetime benefit. You do not need to reopen a claim in the future. The claim stays open for medical care over the course of your entire life. And this is all your medical expenses related to treating that injury, that illness, that part of the body. You know, these are office visits and hospital visits and medication and everything that you would expect in medical care. Surgery, inpatient, yes. Also, we like to point out, we have to travel back and forth for treatment. You can be reimbursed for the transportation costs to treatment. Now, that would be, if you drove, you would get a mileage reimbursement. We tend to use the IRS rate, which is commonly available. So that would be the mileage rate. If you have to pay tolls, you should get that reimbursed. If you took a subway or a bus, you would get the MTA cost reimbursed as well. You use Form C-257. It's on screen. You can get that from our website. Okay, so that's a real quick on your medical benefits. Second benefit is lost wages. These are the financial payments. Okay, in New York, everything is specific to New York, okay? Every state has its own system. In New York, the maximum you could get is 2/3 of your average weekly wage, what you were earning on average for the 52 weeks before you had your incident. We look back and we compute what you got per week on average. Then, your maximum benefit is 2/3 of that amount. Workers' comp payments are tax-free, no taxes at all. And all your compensation counts in this calculation. Overtime bonuses, if you have 2 jobs, you need to tell us about both jobs, because if you can't work one, you can't work the other. The maximum amount you can get right now is on screen, 1171.46. The minimum amount you can get is $275 per week. That is new this year. It went up this year for the first time in decades, or a decade, sorry. And on January 1st, it's going up again. And then a year and a half after that, it's going to be indexed to what's known as the New York State average weekly wage, average payroll. So we do what's called indexing. The maximum right now is 2/3 of New York's average payroll, which is around $89,000 a year. The minimum will also be indexed to 1/5 of that in the near future. So these things adjust every year. What are you getting benefits for? Well, all of our claims, initially are considered temporary, and the worker is either going to heal or, unfortunately, a smaller percentage develops a permanent injury. So temporary benefits, you could be 100% temporarily disabled. That means you can't work. You're going to get 100% of the possible benefit for you. You might heal and get 50% and come to the point where you're 50% temporarily disabled. Well, then you get 50% of the benefit. If you have a permanent injury, you might be permanently totally disabled. That's one of the worst instances. You'd get the benefit for life. You might be permanently partially disabled. You'd get the benefit for between 4 and 10 years. There's a schedule on that. And then also, if you have an injury to a limb and you lose part of the use of that limb, you could get a benefit for that as well. Here are some best practices real quick. Number 1, you might get paid in cash. That's fine. Just encouraging you to keep some records. Maybe write down or make an electronic file. Who paid you? On what date? For doing what? How much did you get? That record might be hugely important. Number 2, if you're getting payments, would you please, please, please consider direct deposit? If you can get a bank account, why on earth would you not have direct deposit? And then finally, please be very cognizant of where you were when you got hurt. If you're working, say, a construction site and you're maybe a day laborer or you move from site to site, definitely record the address where you got hurt. It is so very helpful to us in moving your claim forward. Believe me on this one, please. Finally, the third benefit, funeral expenses. Yes, there is a fatality benefit. And so we just like to call out in the downstate region, defined as New York City, Long Island, Westchester, Rockland, you can get up to $12,500 reimbursed for funeral and memorial. The rest of the state is $10,500. We calculate the weekly benefit payments the same way we do the lost wage payment. And there are certain family members who can possibly receive it. You see them on screen. If those family members don't exist, $50,000 is payable to the parents of the deceased worker. If they are no longer extant, $50,000 is payable to the estate. There is also a national nonprofit known as Kids Chance that provides scholarships to the children of injured workers. We're not affiliated with them. However, we do have their website on screen in case you want to check them out. You might also want to check out the Triangle Shirtwaist Memorial Scholarship. They're another nonprofit that provides scholarships to the kids of workers who either died or were very seriously injured. Now, you might have a hearing here at the board. That means that the insurance payer is going to probably send an attorney. You or your attorney, if you have one, you're going to attend it as well. And it's similar to a court hearing, but it's not quite the same to the extent that we don't use the same rules of evidence and procedure that courts use. We don't technically even operate courts. We have hearings and hearing points. But the point here that I'm trying to make is that if you're a worker, you really should be there, and you really should ask questions of your attorney if you have one. And if you don't have an attorney, you are certainly permitted to hire one. You don't pay your attorney directly. The attorney only gets paid if money is moving towards you, and then they would have some amount of that. And then finally, all of our hearings right now are virtual, which means a teleconference of sorts. You would get a hearing notice and you would be told how to participate in that hearing. We will be doing in-person hearings again in the autumn, but right now we're still on virtual. That's what we wanted to say about comp. I know that was quick, my friends, but we will answer any questions. We do have two more benefits to discuss. Here, very quickly, is short-term disability. This is an insurance, again, that pays claims for workers who cannot work due to an incident that occurred off the job, not on the job. That's comp. This is off the job. You were painting the bathroom on a Sunday when you're at home and you fell off the ladder and broke your leg. Really sorry that happened. And now you can't come to work. Well, you might be filing short-term disability. The other big instance, not that broken legs are the instance, but the most frequent instance is actually pregnancy and post-childbirth. Okay? When mom can't work for 6 or 8 weeks after childbirth, disability can be filed. The benefit is up to $170 per week. That is set in the law. $170 per week for a maximum of 26 weeks. That's it. And to be eligible, if you're a worker, you have to be employed for 4 weeks or 28 days. After that, you can do short-term disability. The medical care is not included here. This is just a financial payment. And workers may be asked to contribute up to 60 cents a week to help pay for the cost of this coverage. The final benefit we're going to speak about real quick is the New York State Paid Family Leave. This is job-protected paid time off for employees to use to take care of family members, it's not for themselves, in 3 instances. Number 1, bonding with a new child. We call that bonding leave. New child, newborn or adopted or fostered. The second instance you can take it is to care for a family member who has a serious health condition. And then finally, the third instance is if you're going to assist a loved one who is being deployed abroad in military service. So what is this now? Well, it is an income replacement benefit. There's going to be a payment. And with this paid time off, you do receive job protection, which means you have to come back to the same or comparable employment. Your health insurance has to continue under the same terms as when you were working, and you cannot be discriminated against or retaliated against for taking this leave. What is the benefit? Up to 12 weeks of paid time off at 67% of your average weekly wage. So it's similar to comp, except instead of 2/3, we actually use 67%, which is a little cleaner, and it's a tiny bit more money as well. And you get that based on, again, 67% of the state average weekly wage. So you can see on screen, the maximum amount you could get is $11 51.16 per week. If the math works out that you would receive less than that, then you would just receive less than that, but this is the maximum amount you can get. Who's covered? Well, most employees who work for private corporations, private employers, for-profits, are going to be coverable. We'll have a little more detail in a moment on that. If you work for a public employer, which is a government, your employer has to opt in. If you're a public employee represented by a union, well, the union might collectively bargain paid family leave for you. Okay, so a little more detail on who's eligible. Covered employees are eligible if they work 20 or more hours per week. Okay, we consider them full-time for PFL purposes. This includes domestic workers, 20 or more hours per week, and you have to have 26 consecutive weeks with the same employer. If you're part-time, which means less than 20 hours a week, you need to have 175 days with the same employer. And once again, happy to say citizenship and immigration status are not a factor in eligibility. Now, here's some contact info for you. We can come back to this later, but you can see we have a paid family leave line. We have contacts for discussing workers' comp and disability benefits. And then finally, there's my office, the Office of the Advocate for Injured Workers. There's my contact info. Feel free to email us, advocateforinjuredworkers@wcb.my.gov. You might get a response in 5 minutes, and I might be writing the response myself. Here is our social media presence. But that was a whirlwind tour through workers' comp, short-term disability, and paid family leave. We will be here for questions. Now I'm going to turn our presentation over to Senior Labor Standards Investigator, Denise Rodriguez of the New York State Department of Labor. Welcome, Denise.
Hi, good afternoon, everyone. So the Division of Labor Standards at the Department of Labor protects all workers, including those who are undocumented or paid off-book wages, and ensures employers comply with the labor laws. Our goal is to ensure that all New York workers receive adequate wages, that their right to a meal or rest day is not violated, and that New York State labor laws are followed. We ensure state labor laws regarding, we enforce the state labor laws regarding minimum wage, hours of work, child employment, payment of wages, agricultural work, nursing mothers in the workplace, and many more. We may impose fines and penalties, as well as investigate complaints related to labor law violations. And all workers have the right to fair wages and are protected by labor laws. All New York State workers are entitled to receive at least an hourly minimum wage rate. This includes fast food workers, nail salon workers, tipped workers, and more. The minimum wage rate varies depending on your region. So the current hourly minimum wage rate as of January 1st, 2024 is $16 per hour in New York City, Long Island, and Westchester, and $15 per hour for the rest of New York State. The state minimum wage is scheduled to increase by 50 cents per year on January 1st, 2025 and January 1st, 2026. So only hospitality employers are allowed to take credit from the minimum wage and reduce the hourly rate of pay based on tips received, so then tips that employees receive. So for any further details, we do have a minimum wage presentation on our website, and you can also refer to the fact sheets that we have on our website for both workers and employers for all industries. As of September 2023, wage theft is larceny under New York State Penal Law Section 155. So failure to pay wages may result in referral to a local district attorney for consideration for criminal prosecution. So the Department of Labor we help collect wages owed to workers who have not received the minimum wage once they file a claim with us. Labor Standards investigates and endeavors to collect on claims for unpaid wages, withheld wages, and illegal deductions, whether it's deducted directly from a worker's wages from their paycheck, or for if a worker pays it through a separate transaction. So we also do not allow taking illegal kickbacks from wages, appropriating tips, unpaid benefits, or wage supplements that the employer has agreed to provide. An employer is guilty of a misdemeanor if they fail to provide employees the benefits or wage supplements that were agreed upon. And wage supplements include vacation or holiday pay, paid sick leave, and reimbursement of expenses. So every employer must notify employees the employer's policy on sick leave, vacation, personal leave, holidays, and hours of work by providing it in writing or publicly posting it. So to file a claim, workers can download and complete the claim form found on our website. And once complete, the form can be uploaded right on our website as well. So the Division of Labor Standards enforces the maximum and prohibited working hours as well as the type of work permitted for minors. For establishments that are covered by the Fair Labor Standards Act, federal laws on minimum wage, overtime, and the employment of minors may in some cases set higher standards than state requirements. So the requirements of state law do not affect an employer's obligations to comply with any of those provisions of federal law. So for further details on federal laws, you can contact the U.S. Department of Labor, Employment Standards Administration, Wage and Hour Division. The hours that minors can work depends on their age, the type of work that they're performing, and whether the minor is attending school. New York State has one of the strictest child labor laws in the country. The law limits the number of hours that minors under 18 may work when school is in session and out of session. For example, to work between 10 p.m. and midnight on a day before a school day, 16 and 17-year-olds need written permission from a parent or guardian and a certificate of satisfactory academic standing from their school. Minors of any age may not work during school hours unless they have graduated or withdrawn from school. And homeschooled children or minors may not work during the hours of the local public school. Between 14 and 17 years of age, excuse me, all minors will need an employment certificate, which we commonly refer to as working papers, in order to hold a job in New York State. So this rule covers high school graduates, minors who work for their parents, minors who do industrial work, so also called piecework. And working papers are divided into two age groups, so 14 and 15 and 16 and 17. And a little tidbit, they're in different colors. Employers are required to post a schedule of work hours for all minors under 18 in the establishment and to adhere to all the other requirements. So penalties for child labor law violations begin at up to $1,000 for a first offense. And for more details, you can see our child labor laws fact sheets also on our website. If child labor laws are not being followed, a complaint can be filed on our website in both English and Spanish. And here's where you can see what it'll look like, right? It'll ask, is the minor under 18, and the additional other questions there. Employers cannot retaliate against their employees for engaging in activity that's protected under the New York State labor law. Retaliation is an action taken against an employee to punish that employee for engaging in such protected activity. So some examples are an employee complaining about labor law violations, providing information to the Department of Labor, exercising their rights to use leave such as sick leave, or participating in proceedings at the Department of Labor. Workers have the right to find out what the labor law requires, complain and ask their employers to fix a possible violation of the labor law, file a complaint with the Department of Labor, pursue all wages owed to them through the Department of Labor or through private legal action, give information to the Department of Labor, answer truthfully when interviewed by a Department of Labor investigator, testify in an official proceeding under the labor law, take an absence that is legally protected by federal, state, or local law, and they have the right to not be retaliated against or punished because they exercise any rights under the labor law. All workers have these rights regardless of their citizenship or immigration status. So on April 3rd, 2020, legislation was signed establishing the right to paid sick leave for New Yorkers. And as of September 30th, 2020, covered employees began to accrue the leave. Covered employees include private sector employees in the state, part-time employees, overtime exempt employees, and seasonal employees. Federal, state, and local government employees are not covered, but employees of charter schools, private schools, and not-for-profit corporations are covered. Employees will receive an amount of sick leave that depends on the size of their employer. So employers with 100 or more employees must provide up to 56 hours of paid sick leave per calendar year. Employers with 5 to 99 employees must provide up to 40 hours of paid sick leave per calendar year. Employers with 4 or fewer employees and a net income of greater than $1 million in the previous tax year are required to provide up to 40 hours of unpaid sick leave per calendar year. I'm sorry, of paid sick leave per calendar year. Sorry about that. And employers with 4 or fewer employees and a net income that is 1 million or less in the previous tax year are required to provide up to 40 hours of unpaid sick leave per calendar year. So please note, the calendar year means a 12-month period from January 1st to December 31st. But for other purposes, including use of accrual leave, employers may set a calendar year to mean any 12-month period. And as an alternative to employees accruing 1 hour for every 30 hours worked, employers may choose to provide the full amount of sick leave that they're required to provide by this law at the beginning of each calendar year. So for example, a business with over 100 employees could provide 56 hours of sick leave to each employee starting January 1st of each year or at the beginning of a 12-month period as determined by that employer. Such upfront sick leave is not subject to later revocation or any reduction if, for example, the employee works fewer hours than anticipated by the employer. Effective October 1st of 2020, employers of home care aides subject to the Home Care Worker Wage Parity Law must provide employees with a notice that details the supplemental benefit portion of the minimum rate of home care aid total compensation. The information must specify the hourly rate paid, the type of supplement or type of home care aid benefits, the names and addresses of the benefit providers, and the plan or agreement, if any, that creates the benefit for each type of benefit. So employers must include information for each wage parity supplement benefit provided and the hourly rate on the employee's wage statement, so on their pay stub. So here are a few of the New York State labor law additional areas of coverage or requirement, such as frequency of pay, day of rest, and meal periods. Overall, employees are entitled to a fair day's pay for a fair day's work, and the New York State Department of Labor is committed to ensuring that every hardworking New Yorker is paid the fair wages that they deserve. Employers are required to provide the following notices to employees. So wage statements, which again are commonly referred to as a pay stub with every pay notice, notice of fringe benefits, and a termination letter. And we have guidelines and directions and samples of each on our website so that employers and employees know what to look for on their notices. As of January 6, 2020, New York employers cannot ask job applicants to provide their wage and salary history as a condition of employment. And as of October 8th, 2019, unequal pay on the basis of a protected class is prohibited. As of June 19th, 2024, all employees have the right to paid break time to express breast milk in the workplace, regardless of the size of their employer or the industry that they work in. Employers are required to tell employees about their rights regarding breast milk expression by providing them the New York State Department of Labor policy on the rights of employees to express breast milk in the workplace when they start the new job and annually thereafter. And as you can see here is a sample of the complaint form. Employees can file a breast milk expression complaint and submit it on our website. As of September 7, 2023, the law requires employers with 4 or fewer employees to disclose the minimum and maximum annual salary or hourly wage in advertisements for jobs, promotions, and transfers, including in electronic postings. The legislation underscores New York's commitment to addressing wage disparities and promoting transparency in compensation practices across the state. It ensures that employees have access to vital wage information and empowers them to make informed decisions about their careers. So proposed regulations to accompany this new law are currently unavailable and were published in the New York State Register on September 13th of 2023. Effective March 31st of 2021, employers are prohibited from discriminating against employees based on the employee's use of cannabis outside of the workplace, outside of work hours, and without use of the employer's equipment or property. We also have a fact sheet which addresses that on our website. And here's just a few different ways that we can be reached through our many different office locations across New York State. That's found on our website. The complaint forms are found there as well. You can contact us via email, which is labor.sm.ls.ask@labor.ny.gov, or by telephone to 1-888-469-7365. Thank you so much.